5 lawsuits against one state law, filed within about 6 weeks of each other, spanning 4 separate state circuit courts and 2 separate federal actions. That is what has happened to Virginia's new assault weapons ban since Governor Abigail Spanberger signed it in May. And if you think that sounds like an unusually intense legal response to a single piece of state legislation, you are right. It is, even by the standards of how contested gun legislation typically gets challenged. But the more interesting story here is not that gun rights groups sued. Everyone predicted that. The interesting story is that the lawsuits are not all playing the same game. Some are trying to win now, in Virginia courts, this year. At least one is deliberately built to lose, on purpose, at the lower levels, specifically so it can be appealed all the way to the United States Supreme Court. Understanding the difference between those two strategies is the actual key to understanding where this law is headed, and it is exactly what most coverage of this story has skipped over. Quick housekeeping. I cover the legal strategy behind major gun law fights, not just who won or lost a single ruling, because in cases like this, the strategy often matters more than any individual court's decision along the way. And understanding which track a given lawsuit is actually running on tells you far more about where this is headed than any single injunction does in isolation. If that is useful, subscribe and turn on the bell, because this litigation is genuinely still unfolding, and I will track every meaningful filing as it happens. 2 seconds, and let's get into how we got here. Start with the law itself, briefly, because the legal fight only makes sense once you understand what is actually being challenged. On May 14, 2026, Governor Spanberger signed Senate Bill 749 and its House companion, House Bill 217, sponsored respectively by Senator Saddam Aslan Salim and Delegate Dan Helmer, both Fairfax Democrats. The law prohibits the future import, sale, manufacture, purchase, and transfer of semi-automatic firearms meeting a feature-based definition of assault firearm, along with magazines holding more than 15 rounds, effective July 1, 2026. A grandfather clause protects firearms and magazines already lawfully owned before that date, meaning existing owners keep what they have but cannot sell, transfer, or replace those specific items within Virginia going forward. This measure followed 4 consecutive years of similar bills passing Virginia's General Assembly only to be vetoed by the previous governor, meaning the underlying legislative will existed well before 2026. It simply needed a governor willing to sign rather than veto it, which is exactly what changed with Spanberger's election. A former federal law enforcement officer who campaigned explicitly on this policy in 2025 and treated it as one of her first major legislative priorities after taking office. It also helps to understand the constitutional backdrop every one of these lawsuits is arguing over, because the same 2 Supreme Court cases show up in nearly every filing on both sides. In 2008, District of Columbia v. Heller established that the Second Amendment protects an individual right to keep and bear arms, not merely a right tied to militia service. In 2022, New York State Rifle and Pistol Association v. Bruin went further, replacing the looser standard many lower courts had used for evaluating gun laws with a stricter historical tradition test, requiring the government to point to an actual historical analog for a modern firearm regulation, rather than simply offering a plausible public safety justification. Neither case directly resolved whether a state can ban an entire category of semi-automatic rifles defined by their features, which is precisely the open question every lawsuit against Virginia's law is now trying to answer, from a different angle and on a different timeline. Now, the moment this law was signed, it triggered what is best understood as 2 fundamentally different legal strategies operating in parallel, and separating them is the key to understanding this entire story. The first strategy, and the one generating most of the news coverage, is the fast-moving state court track. Gun Owners of America and the Virginia Citizens Defense League, working with firearms journalist John Crump, filed a 59-page complaint in the Circuit Court for Lancaster County almost immediately after the signing, a lengthy filing that laid out both state and federal constitutional claims in detail, along with specific factual allegations about how the law's feature-based definition sweeps in firearms these plaintiffs describe as overwhelmingly used for lawful purposes rather than criminal ones. Additional separate lawsuits followed in Washington, Fauquier, and Spotsylvania counties, meaning 4 different state circuit courts were simultaneously considering constitutional challenges to the same law by early July, each filed by different combinations of plaintiffs' attorneys, spreading the legal challenge across multiple judges and multiple jurisdictions rather than concentrating it in a single courtroom. These state cases are playing to win quickly, seeking injunctions that block enforcement while the underlying constitutional questions get resolved in Virginia's own court system, under both the state and federal constitutions. The second strategy is the federal track, and it looks completely different once you read the actual complaint rather than just the press release announcing it. A coalition, including the National Rifle Association, the Firearms Policy Coalition, and the Second Amendment Foundation filed a lean, single-count, 24-page federal lawsuit called McDonald v. Katz in the Alexandria Division of the U.S. District Court, prepared by the law firm Cooper & Kirk. Here is the strategically revealing detail buried inside that complaint. The plaintiffs explicitly acknowledge that existing Fourth Circuit precedent, specifically 2 prior cases, Bianchi v. Brown and Kolbe v. Hogan, both of which previously upheld Maryland's comparable rifle ban, currently forecloses their ability to win at either the district court or the circuit court level. In plain terms, the plaintiffs are telling the court, in writing, that they expect to lose here and are proceeding anyway. That is not a mistake or a sign of a weak legal team. It is a deliberate strategy, and choosing Cooper and Kirk, a firm with substantial Supreme Court appellate experience, to draft a comparatively lean 24-page complaint rather than a sprawling one reinforces that this filing was built for its eventual audience at the certiorari stage, not primarily to persuade the district judge who will actually rule on it first. By building a clean, well-documented factual and legal record now, while fully expecting to lose at the lower federal levels because of binding circuit precedent, the plaintiffs are positioning this specific case to become the vehicle for a certiorari petition to the United States Supreme Court, giving the nation's highest court a clean opportunity to decide, under the text and history standard it established in Bruin, whether bans on America's most commonly owned category of semi-automatic rifle are constitutional at all, a question the court has so far declined to take up directly in several previous opportunities. This distinction between the state and federal tracks explains something that might otherwise seem confusing: why the state cases are moving so much faster and generating so many more headlines than the federal one. State circuit courts do not answer to the Fourth Circuit's precedent. They can independently interpret Virginia's own state constitution, which contains its own right to keep and bear arms provision separate from the Second Amendment, and several of the state complaints are built around exactly that state constitutional argument alongside the federal one. That gives the state plaintiffs a genuinely faster and in some ways more promising path to blocking enforcement in the near term, even while the slower federal case plays a longer, multi-year game aimed at the Supreme Court specifically. It is worth understanding why a state constitutional claim can move independently of the federal one at all. Virginia's own constitution has its own text, its own history, and its own body of state court precedent interpreting it, entirely separate from the Second Amendment and from how federal courts have interpreted it. A state court is free to read its own constitution as providing equal, lesser, or even greater protection than the federal one provides, and Virginia's courts are not bound by Fourth Circuit rulings interpreting the federal constitution when they are specifically applying the state's own constitutional text. This is exactly why a plaintiff with a genuinely strong state constitutional argument might rationally prefer to litigate in state court, even while the same lawyers, or an entirely different set of lawyers, are also pursuing a federal claim they openly expect to lose at the outset. Let me clear up 2 misconceptions about how this kind of layered litigation actually works, because both are easy to get wrong if you are used to thinking about lawsuits as simple win-or-lose events. The first misconception is assuming that a lawyer filing a case they expect to lose at the district and circuit court level is doing something unusual or admitting weakness. It is neither. Building a deliberately losing record at lower courts, specifically to create the cleanest possible vehicle for Supreme Court review, is a well-established, entirely legitimate litigation strategy, used by advocacy organizations across the ideological spectrum for decades, precisely because the Supreme Court generally prefers cases with a fully developed record and a clear, unambiguous lower court ruling to review, rather than a messy, unresolved dispute. The second misconception is assuming that because the state cases are moving faster and winning injunctions right now, they are somehow more likely to ultimately prevail than the slower federal case. That is not necessarily true either. Injunctions granted early in litigation are preliminary rulings based on a plaintiff's likelihood of success, not final determinations on the merits, and a circuit court injunction can still be reversed on appeal even after months of feeling like a settled outcome. The federal case's slower pace reflects a different kind of ambition entirely, not a weaker position. It is aiming for a nationwide binding resolution rather than a Virginia-specific one, which is a fundamentally larger and slower target to hit. Then, on July 1st, 2026, the day the law technically took effect, a third and genuinely unusual player entered the fight. The Trump administration's Department of Justice filed its own federal lawsuit against the Commonwealth of Virginia, arguing the law violates the Second Amendment and specifically citing District of Columbia versus Heller and New York State Rifle and Pistol Association versus Bruin. It is worth being precise about how unusual this is procedurally. This is not a private organization or an individual gun owner suing. It is the United States federal government, through its own Department of Justice, directly suing a state government over that state's own law, a move that adds significant institutional weight to the federal side of this fight regardless of how the case ultimately turns out on the merits, and one that follows an earlier, publicly reported threat from the administration to sue Virginia over this and related legislation even before Spanberger signed anything. It is worth understanding what this DOJ suit adds beyond the private federal case already underway. The Department of Justice bringing its own action, separate from McDonald versus Katz, means there are now effectively two federal lawsuits pursuing overlapping but formally distinct legal theories against the same law, filed by different plaintiffs with different legal resources and different institutional incentives, and potentially different procedural postures if one moves to consolidate with the other, or if a judge decides they should be treated separately. A private advocacy coalition's case and a sitting federal government's case do not necessarily move at the same pace, get consolidated automatically, or even ultimately make identical arguments, even when they are challenging the exact same statute on substantially similar constitutional grounds, which means Virginia's legal team now has to defend against what amounts to two separate federal fronts simultaneously, in addition to the 4 active state court cases, a genuinely demanding litigation posture for any state attorney general's office to manage at once. The public reaction to all of this tracks predictably along the same lines as the litigation itself. Senator Salem, the bill's chief sponsor, called Spanberger's signature a monumental victory for public safety when it was first signed. The NRA responded by calling the law a drastic move to disarm lawful gun owners and confirmed publicly it was taking the fight to court, a promise it has clearly followed through on across multiple filings. House Minority Leader Terry Kilgore criticized the legislation on the floor, invoking Bruin directly and predicting Virginia would lose in court while spending taxpayer money doing so, a prediction the sheer number of active lawsuits has at minimum made expensive to test regardless of the eventual outcome. Notably, the Justice Department's own Civil Rights Division separately and publicly echoed the view that the law punishes law-abiding citizens rather than targeting people who commit crimes with firearms, a position from a federal executive branch office that arguably foreshadowed the DOJ's own subsequent lawsuit before that lawsuit was even filed. On the other side, Virginia Attorney General Jay Jones has consistently maintained that the Commonwealth's legal position is sound and that the law will ultimately be upheld, a position he reiterated even after this week's consolidation setback at the Supreme Court of Virginia. Now let's talk about where the state cases actually stand, because this is where the practical, on-the-ground consequences of all this litigation are currently playing out. Circuit court judges in both Washington County and Lancaster County issued temporary injunctions blocking enforcement of the law, while the underlying constitutional questions get litigated. Because Virginia State Police Superintendent Colonel Matthew Hanley was specifically named as a defendant in the Lancaster County case, the injunction there effectively prevents state police from enforcing the law anywhere in the Commonwealth, not just within Lancaster County's own borders, a detail that illustrates how the specific defendants named in a single county-level lawsuit can produce consequences reaching far beyond that county, a strategic choice by the plaintiff's attorneys that maximize the practical reach of a single favorable ruling. Separately, Commonwealth's attorneys in Washington, York, Frederick, Giles, and Chesterfield counties, along with the city of Chesapeake, are barred from enforcement under their own distinct court orders, meaning multiple, separately obtained injunctions are currently overlapping to produce a patchwork of enforcement authority across the state, none of it currently active anywhere that matters practically. The practical result, as Senator Bill Stanley, a Franklin Republican representing plaintiffs in one of these cases, put it directly, is that Virginia's actual gun law situation right now is functionally identical to what it was on June 30th, the day before this law technically took effect, even though the law itself remains formally on the books. A distinction between formal legal status and actual enforceable reality that is easy to lose track of if you only follow this story through headlines rather than the underlying court filings. This past Monday, the litigation took a procedural turn worth understanding on its own terms. A three-judge panel of the Supreme Court of Virginia declined Attorney General Jay Jones's request to consolidate the 4 pending state lawsuits into one case, following roughly 90 minutes of oral argument. Jones's office had argued consolidation would prevent conflicting rulings across different circuit courts and conserve judicial resources, a fairly standard argument in situations where multiple courts are independently considering essentially the same legal question. The panel's refusal to consolidate means Virginia now faces a genuine possibility of inconsistent rulings. One circuit court could uphold the law while another strikes it down, at least until an appellate court eventually resolves any such conflict, which adds real uncertainty to how and when this actually gets settled statewide. There is a strategic angle worth noting here, too. Plaintiffs generally have their own reasons to resist consolidation, even when a state's attorney general requests it, since litigating in multiple separate forums increases the number of chances to win a favorable ruling somewhere, and a single strong result in any one jurisdiction can still produce the kind of broad, practical impact we just walked through with the Lancaster County injunction, without needing every single case to come out the same way. Senator Stanley, representing plaintiffs, estimated the litigation could run 6 to 8 months as cases move through circuit courts and eventually back to the Supreme Court of Virginia, while explicitly noting that the state and federal tracks will proceed independently of each other rather than on a coordinated timeline. Attorney General Jones, notably, expressed continued confidence in the law's constitutionality despite the consolidation setback, framing it as a procedural loss rather than any signal about the merits of the underlying case, a distinction worth taking seriously since procedural rulings like this one genuinely do not resolve or even meaningfully preview how any court will eventually rule on the actual constitutional questions at the center of this fight. Step back and think about what this 5-lawsuit landscape actually tells you about how major constitutional fights over new state gun laws are litigated in 2026, because Virginia is very likely a preview, not an outlier. Expect any state passing comparable legislation going forward to face this same layered response. Fast state court challenges seeking immediate injunctions, often built around that state's own constitutional provisions in addition to the federal ones, run in parallel with a slower, more deliberately built federal case explicitly aimed at eventually reaching the Supreme Court, sometimes with the federal government itself joining as a direct party if the political circumstances align the way they have here. Watching how these different tracks interact, which one produces a result first, whether the state and federal courts reach the same conclusion or different ones, and how the eventual Supreme Court cert process unfolds if the federal case does get there, is likely to become something of a template for how this exact fight plays out in the next state to pass a similar law, whichever state that turns out to be. It is also worth noting that this layered strategy cuts in a specific, deliberate direction. Gun rights organizations are not simply hoping to win somewhere. They are actively managing a portfolio of cases across different courts and different timelines, accepting near certain losses at some levels in exchange for a stronger shot at the outcome that would actually matter most to them nationally. A level of coordination that says as much about how modern constitutional litigation campaigns are run as it does about this specific Virginia law. There is a broader pattern worth naming here too, because Virginia's situation did not emerge in a vacuum. Assault weapons restrictions have been litigated in several other states over the past decade, and the Fourth Circuit precedent specifically blocking the federal McDonald v. Katz case, Bianchi v. Brown and Kolbe v. Hogan, both arose from Maryland's own similar law, meaning Virginia's fight is legally connected to litigation that has already been running in a neighboring state for years. The Supreme Court has so far declined multiple opportunities to take up the underlying question of whether assault weapons bans are constitutional under Bruin's historical tradition test, and each new case like this one, built specifically to present that question cleanly, increases the pressure on the court to eventually resolve it one way or the other, rather than continuing to let it play out unevenly across different circuits with different outcomes. If breaking down the actual legal strategy behind this fight, not just who is suing whom, was useful, hit like so it reaches people trying to understand how these cases actually work, rather than just who currently has the louder press release. And subscribe if you have not, because 5 active lawsuits moving on different timelines means there will be real developments to cover regularly over the coming months, not just one final ruling somewhere down the road. A genuinely unusual amount of ongoing legal activity for a single state law to generate at once. Tell me in the comments whether you want the next video to track the state court cases as they move toward rulings, likely the faster-moving story over the next few months, or to go deeper on the federal McDonald versus Katz case and its long-term path toward the Supreme Court, a slower but ultimately higher stakes story, because those are genuinely 2 different stories worth 2 different levels of depth, and I would rather build the next one around what you actually want tracked closely than guess.